Good day, everybody. I am Attorney Madril Shea B. D. Guzman. I am your lecturer for Criminal Law, Book 1. Okay. For today's video, I will be giving a brief introduction of criminal law of our subject. We will be discussing the theories of criminal law, the basis of criminal law, the general principles, okay, the elements of a crime in general, the sources of penal laws, and specific doctrines, okay, that are very much applicable in the Philippine jurisdiction. Okay, so brief introduction lang tayo for today's video. Okay, but before that, okay, I will give you the class requirements in order for you guys to pass this subject. Okay, so for this subject, we will be having 2 examinations. Dalawa lang, okay? Kasi mahirap mag-check. Okay? Isang midterm, isang final examinations. Okay. What else? Okay. Aside from the midterms and final examinations, we will be having a recitation. One recitation so that everybody can recite. Okay? If this is a classroom setting, the recitation would be class cards. Shuffling of class cards, hot seat, or firing squad. Bubunot ako. But since I could not do that, okay, I think magwi-wheel of names tayo. Okay, I will schedule one recitation. Okay, magwi-wheel of names tayo. Kung sino mabunot sa wheel of names, siya mag-recite. Okay. Okay, preferably, the sched would be after the midterms and before the final examinations. Okay. So, aside from the midterm exams, final exams, and one recitation, I will be requiring you to make, okay, a class output. Okay. A class output in the form of a reviewer of Criminal Law Book 1. Okay. This reviewer would comprise of, okay, the provisions of Criminal Law Book 1 and include your own notes and examples, okay, other readings, okay, that, okay, you can incorporate and collate in this reviewer, in this class reviewer, which will be a group project of the class, of course, and to be submitted after the final examinations. This class output or class reviewer is for you guys to have an own reviewer that you can use even after passing this subject and during your review. Okay, so since ang idea kasi nun is pag gumagawa ka ng reviewer, nakikinig ka sa teacher mo, you're using your ears, okay. Nagsusulat ka, you're using your hands, okay. And then you read other books and other resources, okay. So you read again and then you update what you have read, okay. And paulit-ulit mong binabasa yung reviewer mo in such a way na ma-master mo na siya. Okay, so pagdating ng review, okay, yung class reviewer na ginawa nyo ngayon sa subject ko, madali nyo nang balikan. Kasi kayo mismo yung gumawa, kayo mismo yung nag-update, alam nyo yung example, alam nyo kung saang particular page nakasulat or naka-encode yung topic na yon. Okay, so that is your class output. Okay, kung titignan nyo, kung may kakilala kayo sa mga higher sections, sa mga seniors ninyo, they made a class reviewer last sem. Sabi ko nga, it will be hard to top what they have done. Okay, yung mga last semester, okay, na estudyante ko for criminal evidence. Okay, you can use that as your guide, but I will still be giving out a guidelines for you in the preparation of this class reviewer. Okay, so what else? Attendance. Okay, I will be requiring you to enter your attendance every schedule. Okay, your class middle will be appointed, okay, to check the attendance every day. And I give premiums to those who will have perfect attendance because that shows diligence. Okay, so meron pa ba? Wala na. Okay, so those are the requirements in order for you guys to pass the subject. Di ba? Madali lang? Okay, madali lang yan. Kayang-kaya natin ipasa itong lahat. Okay. So, may nakalimutan pa ba ako? Wala na. Okay, so let's start, okay, with our lecture proper. Okay, let's start by defining criminal law. Okay, criminal law is the branch of public substantive law which defines crimes, okay, treats of their nature, and provides for their punishment. Again, criminal law is a branch of public substantive law which defines crimes, treats of their nature, and provides for their punishment. Okay. Under this definition of criminal law, we now have the two nature of criminal law. Number one is criminal law is a branch of public law. Okay. Criminal law is a branch of public law. Anong ibig sabihin nito? Okay. Pag sinabi natin criminal law is a branch of public law, it deals with the relation of the state with the individual. Okay. Ang ibig sabihin, kapag may krimen, okay, ako, okay, sinaksak ko si Ronald, okay, ang state, okay, ay may interest, okay, doon sa act na ginawa ko against kay Ronald. Okay. The state will be the one to prosecute me, okay, for the actions that I did against Ronald. Okay. Why? Because, okay, my actions disrupt, okay, the public security and safety. Okay. When we say public law, there is an involvement of the state as contradistinguished to a private law. Si Ronald, umutang siya sa akin ng 1,000,000. Tapos, hindi siya nakabayad. Wait lang, mas mayaman siya. For example, umutang ako kay Ronald ng 1,000,000. Tapos, hindi ako nakabayad. Okay. Pag hindi ako nakabayad, anong gagawin sa akin ni Ronald? Kakasuhan niya ako for collection of sum of money. Collection of sum of money is a civil suit. Okay. Meaning, walang involvement ang state. Okay. Hindi ako pwedeng parusahan ng state. Hindi ako pwedeng ipakulong, okay, sa utang. Okay. Because that involves the private relationship between me and Ronald. Okay. That is only as to private individuals. Hindi mangingialam ang state, ang gobyerno. Kasi yung interest na nandoon ay interest ko lang. Okay. Interest niya lang pala. Okay. Na mabawi niya yung pinautang niya sa akin. Okay? That is the difference between a public law and a private law. And our criminal laws are in the nature of public law. Okay, wherein the state has a say, okay, because of its obligation of parens patriae. Alam niyo yun, the doctrine of parens patriae, meaning the state is the protector of its citizens. Okay, di ba? It's the father of its citizens. So, that is the difference of public law and private law. Okay? Kaya nga, di ba, if it is a criminal case, kapag public law, criminal case, the crime would be people of the Philippines versus Shea de Guzman. Okay? Pag sinaksak ko si Dennis na naman. Nakamupunta tayo kay Dennis, di ba? Sino na nga ba example ko? Si Ronald. Okay? Pag sinaksak ko si Ronald, okay, the criminal case that will be filed against me would be entitled People of the Philippines versus Shea de Guzman. Okay? Hindi yon Ronald versus Shea de Guzman. No. Because the one who prosecutes the crime is the government. Okay? People of the Philippines. Ang plaintiff. Okay? At ako ang akusado. Si Ronald na biktima is a mere witness of the state. Okay? Witness lang siya ng government in prosecuting me. Kasi siya yung victim. Kaya, people of the Philippines versus Shea de Guzman. Kapag sinaksak ko si Ronald. Okay? Si Ronald, witness lang siya. Okay, ng ating gobyerno in prosecuting the same. Pag ang nangyari naman ay umutang ako ng 1,000,000 kay Ronald, okay, hindi ako nakabayad, ang mangyayari doon is a civil case. At ang civil case would be entitled in this manner. Ronald versus Shea for collection of sum of money. Si Ronald ang plaintiff, ako ang respondent. In that case, okay, kami ang maglalaban sa korte. There is no participation coming from the state. Kasi wala namang pakialam ang state kung masingil ba ako ni Ronald o hindi. Okay? So, yon ang pinagkaiba ng public and private law. Okay, criminal law versus civil law. If I'm still going to be your professor in your criminal procedure, i-discuss natin yan ng mas in-depth. Okay? But for now, that would be sufficient. Now, the second important nature of criminal law based on its definition is that criminal law is a branch of substantive law. Okay. When we say that criminal law is a branch of substantive law, it means that criminal law defines, okay, the state's right to inflict punishment and the liability of the offenders. Okay? Pag sinabi nating substantive law, substance, okay, from the word substance, ang ibig sabihin po nito, mga kapatid, ito ay isang uri ng batas na binibigyan ka ng isang karapatan and a correlative obligation. Okay. So, pag substantive law, binibigyan ka niya ng karapatan at ng karampatang obligasyon. Okay. As contradistinguished to a procedural law. Substantive, binibigyan ka ng karapatan. Procedural law is the type of law which provides for the mechanism, for the system, okay, for the procedure by which you enforce your substantive law. Okay. So, ang example ng substantive law ay ito, revised penal code. Okay? Kasi nga, di ba, binibigyan ka ng karapatan, right to life. Okay? Pag na-violate yon, pwede kang prosecute for homicide or murder, as the case may be. Tama? Yan ang revised penal code. Ang example naman ng procedural law ay ang criminal evidence, rules of evidence, rules of court. Di ba? Because these are the laws by which you enforce your substantive laws. Ano pa? Criminal procedure, yung mga yan, okay? Yun yung mga procedural law. Okay, so by this definition of criminal law, it's important to know that criminal law is a branch of public law and it is a branch of substantive law. Okay, so okay na tayo dyan sa definition ng criminal law. Okay? Criminal law is a branch of public substantive law which defines crimes, treats of their nature, and provides for their punishment. Okay. Now, let's go to the theories of criminal law. Okay, theories or philosophies in criminal law. We have, I think, 4. Okay, we have the classical, the positivist or realistic theory, the eclectic or mixed theory, and the utilitarian theory. Okay. When we say classical theory, okay, the basis of criminal responsibility is human free will. Okay. The basis of criminal responsibility is human free will, meaning you are free to do, okay, what you do, okay, and you do those acts voluntarily. Therefore, okay, you know that what you're doing is right and you're still doing it, okay, then you are liable, okay, for the acts or omissions that you committed. Okay. This is based on the legal maxim oculo pro oculo, dente pro dente. Oculo pro oculo, dente pro dente. Yan yung an eye for an eye, a tooth for a tooth. Yung lintik lang ang walang gante. Diba? Sabihin, kapag nakagawa ka ng krimen, kailangan mong maparusahan. Okay? The purpose of the penalty is retribution. Okay? Pag sinabi natin retribution, pagigante. Okay? Na ibalik sa'yo. Okay? Kung ano yung ginawa mo, yun ang ibabalik sa'yo. That is the classical or juristic theory. Okay, the next theory is the positivist or realistic theory. Positivist or realistic theory. Okay, the basis of criminal responsibility is the sum of the social, economic, and natural phenomena in the environment. Meaning, a person acts based on his environment. For example, si Manuel, nagnakaw siya ng turon kasi gutom na yung pamilya niya, ipapakain niya yun sa pamilya niya. Meaning, it is not free will. Unlike in the classical theory that the basis of criminal responsibility is human free will, dito sa positivist theory, the basis is the social economic phenomenon surrounding the circumstances. Ang ibig sabihin, nagawa ni Manuel na magnakaw dahil kailangan niya. Okay? Dahil sa katayuan niya, status niya in life. Okay. In this case, the purpose of the penalty is not retribution, but reformation. Okay. Kung doon sa classical theory, okay, paparusahan mo siya para magdusa siya. Okay. There's punishment para magdusa siya. Dito sa positivist theory, there is punishment para magbago siya. Okay. Para magbago yung actor. Okay. Now, the third theory is the eclectic or mixed theory. Ito yung combination of positivist and classical theory. So, meaning if the crime involves, if the crime is committed and it involves the situation of the person, meaning yung economic, social phenomenon, then you apply the positivist. Otherwise, for heinous crimes, you apply the classical theory. Okay, pinagsama lang. Okay, pinagsama lang dito sa eclectic or mixed. Okay, the last theory is the utilitarian theory. Okay, if it under the utilitarian theory, a man is punished only if he is proven to be an actual or potential danger in the society. Okay. So you just punish him if there is showing that the acts he committed will be a danger to the society. Okay. So, ang example ng classical theory is the revised penal code. Okay. So, pag gumawa ka ng krimen, may specific na penalty. Okay. The revised penal code is actually based on the Spanish Código Penal, which follows the classical theory. Okay. An example of the positivist theory is the law on probation. Okay? Diba? If you are a first-time offender and the penalty is less than 6 years, then you will not be imprisoned. You are entitled for probation. Okay? In order for you to allow to reform. Ngayon, meron na tayong yung community service program. Okay? Yung service ka na lang sa barangay. Okay? Kung ano ang community service na i-provide sa'yo ng barangay, yun gagawin mo for light offenses. Okay? In order to rehabilitate, okay, the accused, and in order for him to allow to re-enter, okay, to re-enter the society as a much more as a better individual. Okay, yun. Ano pa ba? Ano pa? Yung mga sa minor offenders, okay, isa rin yung example ng positivist theory. Okay. For utilitarian theory, I think one example is yung BP22. Okay? 'Di ba yung BP22, okay, normally, okay, under the law, yung Batas Pambansa Bilang 22, okay, there should be imprisonment, okay? But there is a law, People versus Vaca, if I'm not mistaken, okay, kung tama ako, People versus Vaca, the Supreme Court just imposed, okay, the penalty of fine, wala nang imprisonment in BP22 because the accused there was more than 70 years old and he is not a potential danger to society. So in that case, the courts, okay, applied the utilitarian theory. Okay, so tapos na natin ang theories or philosophies in criminal law. Okay?